Something happened in that courtroom this morning that nobody saw coming. Pam Bondi just walked in with 340 pages of documents, and according to people who were in the room, she didn't hold back. I've been piecing this together since the hearing wrapped 3 hours ago. The transcripts started leaking around noon. What I'm about to show you, the major outlets either missed it or they're not ready to report it yet. Either way, you need to see this. Here's the context you need. Pam Bondi, Florida's former Attorney General, Trump's loyalist for over a decade. She defended him through 2 impeachments, stood by him when others walked away, and when he needed an Attorney General in late 2024, he picked her. Confirmed in January 2025. For months, she was the wall between Trump and every investigation coming his way. Southern District of New York, congressional subpoenas, foreign payment inquiries. Bondi shut them down. Until she didn't. Somewhere between February and last week, everything changed. And this morning, she showed up in federal court not as Trump's defender, but as the prosecution's star witness. I want to show you exactly what she brought into that courtroom. Because the headlines are going to say, Bondi testifies, or former AG cooperates. That's not the story. The story is what she handed over. According to the initial court filing released 2 hours ago, Bondi provided prosecutors with documentation spanning 18 months. We're talking wire transfer records, internal emails, handwritten notes from meetings she attended, and recorded phone conversations. This isn't hearsay. This isn't speculation. This is a paper trail built by someone who was in the room when decisions were made. Let me walk you through what I found. First document, Exhibit A in today's filing. I pulled it directly from the court system an hour ago, page 12, paragraph 3. It reads, and I'm quoting here, "The witness provided authenticated records of 7 separate financial transactions totaling $89.4 million, each routed through entities registered in jurisdictions known for banking privacy." That's not my interpretation. That's what the filing says. Now, what does that mean in plain English? Bondi tracked money. She knows where it came from, where it went, and who authorized the movement. But here's the part that got my attention. Page 27, different section entirely. Bondi testified that she personally attended a meeting in Palm Beach in March 2025. 12 people present. The topic was a real estate development deal involving a Middle Eastern investment group. According to her testimony, and this is a direct quote from the transcript, I was told explicitly that certain aspects of the agreement needed to remain off official channels. She was told not to create a record. So what did she do? She wrote everything down. Those notes, kept at her personal residence, were turned over to federal investigators 4 weeks ago. The notes describe a $280 million transaction structured specifically to avoid triggering federal disclosure requirements. I went back through federal filing databases after reading that. The development deal Bondi referenced, it involved a Delaware-based LLC called Meridian Coastal Holdings. I searched corporate records. That company was registered 9 days before the first payment went through. No prior business activity. No employees listed. No physical office address. Then, 2 months after the final transaction, the company dissolved. Just disappeared from the registry. You don't set up a shell company, move $280 million, and dissolve it 2 months later unless you're trying to hide something. And Bondi documented all of it. But wait, it gets more specific. Page 34 of today's filing references what prosecutors are calling Exhibit F. Bondi handed over 62 emails. The emails span a 3-week period in April 2025. All of them involve correspondence between Bondi, 2 senior White House advisors, and an attorney representing a foreign sovereign wealth fund. I looked at the subject lines listed in the filing. One of them says, "Revised structure to minimize reporting threshold." Another one says, "Offshore confirmation required by Friday." These aren't vague business communications. These are emails discussing how to structure financial arrangements to stay under regulatory radar. And the Attorney General of the United States was part of those conversations. What nobody's talking about yet, and I mean nobody, is page 58, buried deep in the appendix. Bondi testified about a phone call she received in June 2025 from someone identified only as Individual 1 in the transcript. That call, according to her testimony, involved a direct instruction to delay a Department of Justice review of a specific foreign acquisition. The acquisition involved a U.S.-based technology firm being purchased by an entity with ties to a foreign government. Normally, that triggers a CFIUS review, Committee on Foreign Investment in the United States. It's designed to evaluate whether a transaction poses national security risks. Bondi says she was told to slow-walk the review process, and she did, for 6 weeks. Then the acquisition went through without full committee evaluation. That's obstruction. That's interference with a federal oversight process, and she admitted it under oath this morning. The fallout started before she even left the witness stand. By 11:30 a.m., 3 additional subpoenas were issued. 2 went to former White House staffers. 1 went to a private attorney who represented the Delaware LLC I mentioned earlier. Within 2 hours of Bondi's testimony, prosecutors requested expedited access to banking records from institutions in the Cayman Islands, Switzerland, and the United Arab Emirates. They didn't wait. They moved immediately. That tells you they already knew some of this was coming, and Bondi's testimony gave them the legal basis to go after the rest. Now look, I need to be fair here. The other side has a response, and parts of it are legitimate. Trump's legal team put out a statement this afternoon. They're calling this a politically motivated prosecution. They're saying Bondi is a disgraced former official trying to save herself by fabricating evidence. And honestly, there's something to that argument. Bondi does have an immunity deal. According to sources close to the case, she signed it on Monday. That means she's not facing criminal charges for anything she reveals. So, yeah, she has an incentive to cooperate. She has an incentive to give prosecutors what they want. That doesn't mean she's lying, but it does mean her testimony comes with built-in motivation. Trump's lead attorney, someone who's been with him since 2019, said this in a press conference 2 hours ago. This is a betrayal orchestrated by prosecutors who couldn't build a case on facts, so they bought a witness. I don't agree with all of it, but that's not an unreasonable position. Immunity deals do create pressure. Prosecutors don't hand out immunity for nothing. They expect value in return. And if Bondi didn't deliver something significant, she wouldn't have gotten the deal. So the defense argument is, she gave them what they wanted to hear, not necessarily what happened. That's a real legal strategy. It creates doubt. Second point from the defense. None of the financial transactions Bondi described have been proven illegal. Complicated? Yes. Involving offshore entities? Sure. But offshore accounts aren't automatically criminal. Thousands of legitimate businesses use LLC structures in Delaware and Nevada for tax and liability reasons. Just because something looks suspicious doesn't make it fraud. Former federal judge, now teaching at Georgetown Law, said this on a legal podcast this afternoon. Complex financial structures are not evidence of intent. You need to prove the intent to deceive or defraud. Structure alone doesn't do that. That's a fair point. Prosecutors have to show that these arrangements were designed to break the law, not just to minimize taxes or protect assets. Third, the timeline. Bondi was part of the administration. She was in those meetings. She had access to those conversations. But she was also a political appointee serving at the pleasure of the president. If she had concerns about illegal activity, why didn't she report it at the time? Why did she wait until she was facing her own legal exposure? That question matters. It goes to credibility. The defense is going to argue that Bondi's cooperation isn't about truth, it's about survival. She saw prosecutors closing in on her, and she flipped to protect herself. That's a compelling narrative, and juries pay attention to motive. Here's what I keep coming back to, though. Bondi didn't just show up with stories. She brought documents, physical, verifiable documents, emails that have metadata, timestamps, digital signatures, wire transfer confirmations that can be matched against bank records, handwritten notes that can be authenticated through forensic analysis. You can question her reasons for cooperating. You can question whether she's exaggerating or embellishing. But you can't question whether the emails exist. You can't question whether the wire transfers happened. The paper trail is real. And that's what makes this different from a typical cooperating witness scenario. If this were just Bondi's word against Trump's, the defense would have an easier time. Reasonable doubt everywhere. But it's not just her word. She brought the receipts. This didn't come out of nowhere. Let me give you the backstory. About 8 months ago, cracks started forming. Bondi and Trump's inner circle had disagreements about how to respond to federal subpoenas. She wanted to comply and cooperate. They wanted to delay and fight. Publicly, everything looked fine. Privately, Bondi was being cut out of key decisions. She still had the title, still had the office, but she lost access to the meetings that mattered. Then, around the holidays, her name started appearing in a separate investigation. Not as a target, but close enough. A Senate aide told Politico back in December, she saw how this was going to end, and she made a choice.
What happened?
It's a pattern we've seen before in this administration. Loyalty is rewarded until it becomes inconvenient. Legal exposure is handled individually, not as a team. When pressure mounts, you're on your own. Bondi watched Michael Cohen. She watched what happened to Rudy Giuliani. She watched people stay loyal past the point of legal safety, and she watched them go down alone. So she made a different calculation. And the difference this time is that Bondi had access others didn't. Cabinet-level access. She sat in on classified briefings. She was in conversations that should never have happened in front of someone who might one day become a witness. And now, prosecutors have all of it. People keep asking me, why would she keep notes? Why would she save emails? Maybe it was insurance. Maybe it was instinct. Maybe from the beginning she knew this could happen. Either way, it happened. And as of this morning, her testimony is on the record. Let me show you what happened at 10:15 this morning, because this is the moment that changed the room. Bondi was under direct examination. The prosecutor asked her about a specific conversation she had in the Oval Office on February 22, 2025. She paused, looked at her attorney, then she answered. I was present when the president discussed structuring a foreign partnership to avoid congressional notification. The room went silent. Trump's defense attorney immediately stood up and requested a sidebar. The prosecutor asked for a recess. 2 reporters got up and walked out to file. It took less than 5 minutes for that quote to hit Twitter. When the hearing resumed 20 minutes later, Bondi walked through the details. The partnership involved a $340 million infrastructure project in the Middle East. American developers, foreign financing, and, according to Bondi, explicit instructions to keep the structure below the threshold that would trigger mandatory congressional reporting. Here's what people missed while they were focused on the dollar amount. Bondi named names. Not just Trump. She identified 9 other people who were in that meeting or involved in the deal. Current officials, former advisors, 1 sitting member of Congress. The transcript was partially sealed within 90 minutes, but not before the basics got out. And here's the tell. By this afternoon, one of the people she named had already hired a white-collar criminal defense attorney out of Washington. Nobody asked him to comment. He volunteered a statement denying any wrongdoing. That's not the behavior of someone who's confident. That's someone who knows what's coming. The congressman's office? No comment. Referred all inquiries to legal counsel. Also telling. And the judge's response? She scheduled an emergency status conference for Thursday. Moved up the timeline. That wasn't reactive. That was calculated. You can see it in the docket. Prosecutors filed a motion for expedited discovery this afternoon. It was granted within 3 hours. Something in Bondi's testimony made them move faster. We'll find out what on Thursday. Here's where it gets really interesting. The sealed portion of today's transcript. Bondi testified for 5 hours. Only about 2 hours are public. The other 3 hours are under seal at the prosecution's request. We don't know what's in there. But we know it was sealed to protect an ongoing investigation. That means there's more. Either more people involved, more transactions, or more evidence that hasn't been made public yet. Thursday's hearing will tell us whether that seal stays in place or whether more gets released.
What are the experts saying?
I reached out to 3 former federal prosecutors today. First one, 19 years at the Southern District of New York. She said, when someone at Bondi's level flips and brings documentation, cases move fast. This isn't a minor development. This is seismic. Second one, criminal defense attorney with 25 years in federal court. He told me, the immunity deal is the key. Prosecutors don't give immunity unless they're getting something worth more than the charges they're giving up. She brought them something big. Third, a former DOJ official under 2 administrations. He said, the documentation is the problem for the defense. You can challenge a witness's credibility. You can't challenge a wire transfer record. When both exist together, that's when cases become unwinnable.
Even people who used to work for Trump are admitting this is serious. A former White House attorney spoke to CNN this afternoon and said, if the documents back up what she's saying, this is a major problem. You can discredit testimony. You can't discredit banking records. Why should you care about any of this? Let me make it practical. If you have investments in U.S. markets, this matters. Political instability moves markets. On Friday, after rumors of BONDI'S cooperation first leaked, defense sector stocks dropped 1.8%. Uncertainty about foreign deals spooks investors. Your retirement account, if you have one, probably has exposure to companies that are now reviewing their own compliance procedures. I'm not giving you investment advice, but I'm telling you what markets are already reacting to.
Precedent matters too. If a sitting attorney general can be compelled to testify against a sitting president with full documentation, the rules around executive privilege just changed. Every future administration will calculate differently. Every future official will think twice about what they document and what they don't. If you work in government, if you work in politics, if you work anywhere near federal contracting, this case is now the reference point. Who's affected right now? According to the unsealed portions of today's testimony, 27 individuals are referenced. 11 were named directly. 16 are described by title or role. Prosecutors know who they are. The public doesn't. Not yet. But federal employees and related agencies are already being told to preserve all documents. Legal hold notices go out Monday. That means if you work in certain parts of the government, you're about to be told not to delete anything. Not emails, not texts, not handwritten notes. Everything gets preserved pending investigation. Here's the uncomfortable part nobody wants to say out loud. If these deals are structured the way prosecutors suggest, then decisions made during the administration were influenced by financial arrangements that weren't disclosed. Policy decisions, regulatory appointments, enforcement priorities. If you voted in the election, if you pay taxes, you're part of this. Not because you did anything wrong, but because government decisions were made on your behalf, and now we're finding out those decisions might have been influenced by money we didn't know about. What are informed people doing right now? They're watching investment exposure in sectors tied to federal contracts. They're following the Thursday hearing for additional names. They're asking financial advisors about exposure to companies involved in these transactions. Knowledge is the advantage here. Here's the bigger picture. Bondi wasn't some fringe player. She was inner circle, true believer, defender-in-chief. If she flipped, other people are doing the math right now. They're sitting in offices across Washington, having quiet conversations with attorneys, asking the same question. If this is where this is going, what's my exposure? The first domino fell this morning. We're waiting to see if others follow. Trump's response made it worse. By this afternoon, he'd posted 8 times on Truth Social, called Bondi a confused, desperate woman who was never smart enough for the job. Said she's making up stories to save herself from prison. One post said, she was always weak. I should have seen it. The reaction? 6.2 million views in 4 hours. Bondi's legal team requested additional security this evening. That's how fast this is moving. Republican leadership is scattered. Some immediately defended Trump, called this a deep state operation. Others went silent, noticeably silent. One senior Republican senator, unnamed but described as close to leadership, told a reporter this afternoon, "We need to see what's in the sealed documents before making any judgments." That's not a defense. That's distance.
They're waiting to see how bad this gets before they commit. Trump's legal team filed a motion late this afternoon, trying to exclude portions of Bondi's testimony. They're claiming attorney-client privilege on some of the conversations she described. Prosecutors already responded. They're arguing Bondi wasn't acting as Trump's attorney during those conversations. She was a witness to them. That fight happens Thursday. And every legal analyst I spoke to thinks the privilege argument fails, which means more of her testimony becomes public. What's still unclear? 3 big things. 1. What's in the sealed testimony? 3 hours of hidden content. 2. Who's the sitting congressman she named? We know there's one. We don't know who. But their office knows, and they're already lawyering up. 3. The full foreign element. We know Qatar, Cayman Islands, and Switzerland are involved. We don't know the scope yet. That's coming. Dates to watch. Thursday, March 12th. Status conference. The privilege fight gets resolved. If Trump loses, more testimony becomes public. If he wins, he buys time, but not much. Following Thursday, grand jury reconvenes on March 16th. New evidence expected. We should know more by next week. This is the holding pattern. Uncomfortable, uncertain, moving faster than anyone predicted. Subscribe if this breakdown helped. When the sealed documents come out, I'll go through them the same way. Evidence first, then analysis. No hot takes, just what's in the filings. Notifications on. This is moving fast, and I'll be here when it does. Talk soon.